Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, chairman of the board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, Paul Melnick, and Peter Owen. Also present is the professional staff, including Sam Emba, secretary to the Board of Zoning Appeals, Arlova Vaughn, zoning administrator, Simon Keynes, administrative technician, and Blake Bowen, assistant to the zoning administrator. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you have not yet seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the power and authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots, where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask questions of any staff that they may have. Next, applicant or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances, For use permits and variances, we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-11287-17-VA-1. Variance request by Carmichael Construction, the owner, to permit development on a lot that does not meet the minimum average lot width requirement for a 2-story dwelling in Arlington zoning district on premises known as 4074 35th Street North. Staff recommends that the board adopt the attached resolution granting the variance request.
Thank you. Questions for staff? We hear from the applicant, please.
I hand this to you. I'm here on behalf of Carmichael Construction. Michael Carr, our principal and owner, is out of town. He's been out of town for a week and a half. So he asked that I come represent the company. A note from our engineer, the point of kind of our justification was that the lot and the ordinance was created in 1952. The actual lot itself, by right, has been as such since 1952. We bought it with the intention of doing an infill, tear down, rebuild. So we're planning on building a new home. It's kind of like we're handicapped by the shape of our lot. If the width of the back property line had been wider, then we wouldn't be dealing with this issue. But other than that, I mean, the house is by right, a new home since 1952, and it's been as such since that date. We're not asking for any, unique variances here. We're just asking that I guess it's the average width. I think ours is around 70 feet, be acceptable, as opposed to, what the current ordinance requires. I think it's 80 feet. So.
Thank you. Any questions for the applicant's representative? Mr. Malnick.
Yes, so of course, with variances, there has to be, a finding of an unreasonable restriction in the use of the property or hardship.
Mm-hmm.
And I noticed in your letter, in your statement of justification, you stated that, and this is on, it looks like page 2 of your statement of justification. You said, while remodeling in and of itself can certainly be a viable option for some, it is not the only option others have. Therefore, we may be more restricted more than those around us. So it sounds like it is viable to develop this based on the current improvement. But the unreasonable restriction is that other people around you, are being able to put new structures in. And so I wanted to ask that, because if it's viable, then it doesn't seem like it would be an unreasonable restriction to impose the law as it is. You see?
I would disagree in that at this point, the pro forma that we did was based off an analysis of new construction. And, this is the first time our engineer, who's worked in Arlington for 20 some odd years, has even come across like the average width requirement, because again, he's been dealing with rectangular shaped lots that don't really deal with an issue where like the rear lot line is several feet, 20, 30, 40 some odd feet more narrow than the front lot. So again, our pro forma had nothing to do with a renovation. We looked at it as strictly a tear down rebuild. And at this point, we've come up, I don't know, with how many thousands of dollars towards a grading plan, new architectural drawings. It was never looked at for us from our perspective, as a renovation project. So, I mean, that is the short answer from our perspective, is that we just didn't really look at it as a remodel. And perhaps had we had a client that wanted to maybe renovate the house, and that'd be a different story, but this is a spec home for our company, and it's not, we don't have like an end user at this point. So, I mean, at this point, we're on top of purchasing the land and you know, again, spending thousands of dollars in entitlement cost and, you know, cost to come up with plans and so forth. We're not, I mean, we'd be in a bad spot if we had to turn this into renovation at this point.
So is that a mistake in the letter, you know, saying that it's certainly a viable option for some, you know, the renovation? You know, because maybe, did I misconstrue that?
No, I don't think I think he possibly worded it in a way that, because our engineer and, you know, myself and Mr. Carr reviewed it shortly, but didn't really, I must have not looked at that close enough and thought, oh, this could be an issue. But yeah, we never thought of this as a potential renovation. But yeah, had we had a client that would have looked at it with us as a potential remodel, then, you know, maybe we would have gone that route. But this is a company-owned property. And, you know, from our perspective, it was always going to be an infill development.
Okay, thanks.
Other questions for the applicant? Mr. Owen?
You're proposing to meet all the setbacks and coverage requirements, right?
Yes, sir.
So this is just to make it a buildable lot.
Yes, sir.
Your argument is that all your adjoining neighbors have the option of putting a new home on their lots, and that's why you are unique.
In fact, actually, the neighbor 2 doors down to the left is a brand new construction. Neighbor across the street is brand new construction. So yeah, more than anything, we're just handicapped by the odd shape of the lot.
Okay, thank you.
Thank you.
Any other questions? Mr. Malnick?
Thank you. So, you know, the question goes to whether or not, let's see, let me get the wording here. Let's see, whether or not the property was acquired in good faith and that any hardship was not created by the applicant. So you must have known that, you know, in order to do what you wanted to do with this, you'd have to get a variance. So
No, we didn't. In fact, we didn't.
Oh,
Again, this was something that came up after we had submitted for a building permit. Upon the LDA giving us like the first round of reviews and their comments, rather, that's when we found out that this was going to be an issue. And again, when we heard from our engineer that, again, he's been working here for 20-some-odd years, or working with the county for 20-some-odd years, he said this is the first time this has ever been an issue for him.
okay.
So again, when we did our kind of our due diligence period up front, this didn't come up because he hadn't dealt with it previously.
Okay.
Perhaps that's a poor excuse for him, but, you know, for us, we had no idea until we'd submitted for an LDA and a building permit.
Okay. All right, thanks for the explanation.
Comments? Questions? Motion?
Madam Chair,
Ms. Malice?
I find the applicant's argument compelling, that there is a hardship here and that a variance ought to be granted. And so I move that the Board of Zoning Appeals adopt the attached resolution granting the variance V-11287-17-VA-1.
I'd second that motion.
Moved by Ms. Malice, seconded by Mr. Smith.
Madam Chair,
Mr. Smith?
I note that there are people in the audience. I know that there weren't any other speakers, but there are people who had picked up this application. I was wondering if there was an intent, if you had supporters here.
Aside from the letters of support from neighbors adjoining and across the street, no, we didn't have anyone to accompany us.
So been moved and seconded. All those in favor?
Aye.
Opposed? Thank you. Next case. Excuse me?
Madam Chair,
Mr. Owen?
I move to reconsider the previous vote.
Can a majority voter reconsider the vote?
I think so.
That was only the minority.
Huh?
I only thought you could reconsider if you were in the.
No, it's the opposite.
Opposite,
Only the
that's right.
prevailing side can move to reconsider.
I second the motion.
Okay, moved and seconded to reconsider. All those in favor?
Aye.
Okay, now, sir, who are you?
I'm a neighbor. I live on 4082 35th Street.
Okay,
Property, we're on the right.
as we explained at the beginning, you need to submit a speaker slip. Actually, before the item is called, but given the issue. Okay, here's another one.
Good for you.
And for everybody else in the audience, can we please
Are we
be
on?
aware of when your item is? Sorry?
87, they're on 80, they're for 87. Yeah.
35th Street. 3 on 35th Street. Okay. Okay. Hold on. Are you Claude?
No, I'm Cyril.
Please begin.
Okay, sorry for the mix-up.
And identify yourself, please, for the record.
Yes, Cyril Bronac, living on 4082 35th Street North.
4082.
Go ahead.
All right, so we received this letter that says it does not meet the minimum average lot width requirement. So what does that mean exactly? I mean, is a house being built too wide for the land? So that was one question we had. Another question we had, we received a letter from Carmichael Company about the fact they're going to have to work on the roots of our trees. We have 2 big oak trees and a small line of little trees. So I want to make sure that whatever is done doesn't endanger the life of these trees. And if it does, who is going to be responsible for removing or working on these trees? As you know, it's very expensive to do that. And basically, we don't want to have a house. I know they got the approval from other neighbors, but they live across the street from the project. We live right beside it, and we had a bad experience in the past of a house that has been built on top of us on the other side. So we don't want to have the feeling to live in a canyon. So we want to make sure that the height is not beyond what is legally possible, and also that the house doesn't go in too much into our backyard, for example.
Okay, thank you. Kristen?
Madam Chair,
Mr. Owen?
I would just point out to the speaker that after all the speakers go, we'll probably have a discussion in which some of your questions might be addressed.
Thank you.
Kristen?
Yes, I'm Kristen A. Jabour. I live at 4066 North 35th Street, which is right next door on the other side from Flipper. A representative from Carmichael came by to my house and gave me a copy of this neighborhood consent letter. I filled it out. Here's a copy of it. I had lots of comments. It's not included in this package. I don't know if I have time to go over my comments since the company didn't include it. Just to make it short, I'm worried about heavy trucks and equipment sitting at the curb idling with their gas fumes coming into my house. and the noise and all of that. This has been a common thing with other construction projects in the immediate neighborhood. And sometimes they arrive really early in the morning and they sit there until 7 o'clock. I guess that's the time when you're supposed to start. I'm worried about the retaining wall because of water runoff from properties above. I'm afraid that the retaining wall might kick some of that back into my property. I'm worried about the root pruning. I don't see why it's necessary because all of my trees are at least 6 feet, 5 or 6 feet above the ground level on that property. I would rather not have any root pruning at all. Another comment I had, I don't want any exterior lighting to be placed so that it shines into my windows or into my backyard. And that's just a brief summary of all the things that were not taken into consideration by whoever did up this package.
Okay, thank you. And Claude?
My name is Claude Bronac. I'm Cyrus Bronac's wife. I'm basically echoing everything he said, that we don't want to live in a canyon. I also am concerned with the retaining walls, the trees that are going to be pruned that might die, or we'll have, to take care of it. And the retaining wall, it's going to be, just imagine if you have that just this way and another house that looks like a Navy ship on the other side. We're really concerned that this neighborhood is not becoming, the neighborhood that we wanted to live in. And all the, this is houses, 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 and the nature is killed, basically. There is no backyard. Yes, we have across the street a big house, but they have a lot that was maybe 3 times the lot of the one that is just next to us. We have a lot that is basically the same side. We are doing renovation at the moment, and we have decided not to touch the print of the house, but rather go a little bit higher in order to preserve everything that is in the back, the oak trees, the nature, basically, and respect at least that in the neighborhood. So this is a big concern of ours, and it's big. It's a big project for the lot. I think it's too big of a project. Maybe, when they went into buying the house, they thought they could do it, but maybe they could have thought about it a little more and reduce the scope of work. Thank you very much.
Thank you. Thank you. Questions or comments?
Madam Chair,
Mr. Owen?
the additional evidence presented by the neighbors calls into question whether or not this variance fulfills, as presented, the second condition for variances required under statute. Granting the variance will not be of substantial detriment to adjacent property and nearby properties in proximity to that geographical area. So I think that my own view on the legal sufficiency of this variance is somewhat adjusted by the neighbors' input. I do wonder whether or not some additional time for the neighbors and the applicant to talk could address, it's not uncommon for us to have neighbors and applicants talk about things like tree preservation, lighting design, that sort of thing, and work out compromises that make all parties satisfied. And what I would be interested in colleagues' view on is how much of that we should discuss tonight, if at all, versus seeing if a little more time can allow the applicants and the neighbors to try and work some of these issues for us.
Other comments?
Madam Chair,
Mike?
let me address just a couple of things that the neighbors had concerns about. First, the height. The applicant proposes to build a structure that is lower than the height required, lower than the maximum. The maximum is 35 feet. The structure they propose is a little less than 34 feet, 33.8 feet tall. And then construction traffic, obviously, they have to comply with a lot of laws that relate to the idling of diesel vehicles and the time zone, the time period during which construction traffic can occur and construction can occur. That's unrelated to our authority, but there are other rules and regulations that govern that, that they would have to live up to or they'd be cited. Trees. If there are trees on that property, the county does have an interest in preserving old growth, unique trees that are valuable to the county and that provide shade and it doesn't look like that is really the case here. There is some tree growth, but it doesn't look like that it's the kind that would be of a great concern. About the width, about the placement of the structure, their plan is not to go wider, to build a structure bigger in terms of the closeness to the side yards than the law allows. But what the problem with this lot is that if you can see, it's kind of pie shaped. And so what happens is you have to average the width. If the back of that pie were just a little bit wider, their average width would be 80 feet. It's a little narrow, so their average, you see in the front it's much wider than the minimum of 80, but in the back it's much narrower, so the average is 72. That's their only problem, and it's a unique problem. Other lots in that neighborhood, it's an R10 neighborhood, average at least 80 feet, thus they don't have this unique problem. So I say that to say that I understand the concern of the neighbors, and but I don't think that it's what they propose is of substantial detriment to the neighbors. And during any construction process, the neighbors should make themselves known to the construction managers, and any unpleasant experiences they have, they should let those folk know, because the county would the county would want to know that the construction is being done in accordance with the law and to the satisfaction, to the extent that it can be done, of the neighbors. Thanks.
Any other comments?
What Mr. Owen suggested is not uncommon to defer. My inclination would be to see if we can't attempt to address some of the issues tonight and see if we can't decide if we can't move this forward one way or the other tonight. In terms of the construction traffic, I think one way that this has been handled is that the applicant provides a phone number to the residents, a cell number that they can call immediately if any of the vehicles associated with the construction are idling inappropriately or in any other way. So that would be one suggestion I have. On the issue of the trees, I'm not sure, and maybe the applicant could come up and talk about the root pruning and whose roots are being pruned and what the concern is from your understanding.
Per the county requirements, we have to send the adjoining neighbors a letter telling them that tree number 1 through 4 will be affected if we weren't to do root pruning, but our arborist is proposing to do root pruning to protect any trees that are off-site. So you have your limits of disturbance, which if you look at the red line, essentially we'll have silt fence put up all around the property, all around the limits of disturbance. And where you install the silt fence, they do root pruning, which is they'll take a trenching machine, which will dig approximately 18 to 24 inches underneath the ground to prune those roots back. And that silt fence will actually go all the way down into that trench, presumably protecting those trees off-site from any disturbance that is on-site within the limits of disturbance. So again, those letters were sent on our behalf to the neighbors to alert them of what was going on. And if I may, the reason we didn't submit the adjoining neighbors letter was because Mr. Carr's been out of town, and there was also a deadline for giving all the letters of support and of objection, so we weren't able to get those in by the deadline. But again, per the root pruning, these are all kind of things that are decided upon by our arborist, who we follow all of his guidelines and things of that nature. So, but yeah, as far as giving the neighbors our cell phone and pertinent contact information, we're entirely fine with that. Anytime they want to call, in fact, they have my cell phone currently. The number that's on the notification letter to the neighbors is my personal cell phone number. I'm one of our project managers. I'll likely be on site daily at this job. So again, if they have any concerns at all, they can approach me while I'm on site, or they can give me a call anytime.
You're taking the trees down in the back?
I don't have the tree plan with me, but I could point out on our tree plan which ones are coming. The trees that are inside the limits of disturbance have to go, because there's going to be heavy machinery demolishing the
All the
home.
way to the back?
No, not all the way to the back, but again, the limits of disturbance don't necessarily follow that red line entirely. They go inside of the red line, and then anything that's outside of the limits of disturbance we try to preserve. But the ones that are affected by the actual footprint of the house, we obviously have to take those out.
And those are in let's say, the front 2/3 of the property?
Roughly. Yeah, so there's a tulip poplar on the right-hand side that's like 20 plus inches in diameter. That one's got to go because
On your property?
it is on our property.
And you have county regulations to meet?
Absolutely.
With regard to
In fact, we can't
replacements?
get a building permit before
Have your
our
replacements.
LDA and our building plans are approved.
All right, well, let me stew on that a minute. Thank you.
No problem. Thank you.
Mr. Melnick.
So I'm in agreement with Mr. Smith about what he said. I'd be inclined to move on this tonight instead of delaying it, just on account of what he said and what I've heard from the speakers.
Are we good?
Madam Chair?
Mr. Smith.
Well, I'd move that the Board of Zoning Appeals adopt the attached resolution granting the variance in V-11287-17-VA1, subject to the conditions that are listed in the approval resolution.
I'll second.
Moved by Mr. Smith, seconded by Mr. Melnick. Mr. Owen.
I do think that the rationale for this variance is sort of classic variance, that there's an unusual shape of the lot, and that what they're planning to do is build a typical, maybe not typical for what's there today, but typical for new construction house in this neighborhood on a slightly atypical lot. And that's basically what variances are for. I would prefer that we defer this item. I don't think I'm in the majority, so I'll vote no for that reason, but that's my rationale.
Okay. We have a motion on the floor. All those in favor of approval? Aye.
Aye.
You calling for the no's?
Those opposed?
No.
We have three for, one against, one abstain. You have your variance. Thank you.
To the neighbors, I don't know if you got a copy of the staff report that was created for this item, but you can pick one up from that table, and that might help you better understand what was going on.
Next case, please.
Case number V-11288-17-UP-1. Use permit request by Andrew J. Monaco and Patrick N. Forrest, owners to permit a setback of 7.3 feet to the wall of the rear addition instead of 8 feet as required, and 4 feet to the eave instead of 5 feet as required from the right side property line, and 10.1 feet to the wall of the addition instead of 21 feet as required, and 9 feet to the eave instead of 10.1 feet to the wall of the addition instead of 25 feet as required, and 9 feet to the eave instead of 21 feet as required from rear property line. for a two-story rear addition in R5 zoning district and premises known as 1035 19th Street South. Staff recommends that the board adopts the attached resolution approving a setback of 7.3 feet to the wall and 4.4 feet to the eave of the addition from right side property line, but denying the subject use permit request for a setback of 10.1 feet to the wall and 9 feet to the eave of the addition from rear property line. An alternative resolution has been provided should the board wish to approve the use permit as advertised.
Thank you. Questions for the staff? Applicant, please.
Good afternoon. Ben Keeney. I'm actually here today speaking on behalf of the applicant, good friends of mine. I'm a local
Mr.
architect.
Keeney?
Yes, ma'am. Andy and Patrick basically told me that they had an idea of their house. They were interested in basically having a larger structure. They have children, and they're interested in having the ability to have their aging parents stay with them. So it's right now they have a fairly small, petite structure on the lot on 1035. If you have a site plan, the overall house has this nice charm to it. They basically want to add onto the structure. They don't want to tear it down. So it's another fairly typical BZA type of request. We have an existing structure that's within their side yard distance. So the addition they propose basically comes directly out of the back of the existing house, and it would go and also infringe into the rear yard requirement. Their lot coverage is 46%, which is lower than the 48% maximum. They've acknowledged that they could basically tear the entire building down and move it over a couple of feet, but realistically thought that there's something to be said about the older building and the older structure. That's not something you can go and just replace overnight. It's, new materials. They're not going to have that charm necessarily. So that's basically the gist of the relief requested by the applicant. I would say that there is at least 25 feet from the back of the proposed addition to the building on lot 1034, and there's another 19 feet on the existing side yard between the applicant's property and the structure on 1029. So nobody walking through the neighborhood would really know where the property line was. It's 19 feet between the buildings. So it looks compatible, in my opinion, with the majority of the adjacent structures throughout the block. I know the staff report disagrees with the rear yard setback. However, we feel that it's not likely that the neighbor behind is going to go and squash the buildings together. I think that's going to be something that they've already got their building fairly close to that property line, while this building is closer to the front street. That's it for the gist of the architectural and zoning jargon. I think the staff report covers all of the details very well. But I think the applicant wanted to stress, having the charm of the existing structure intact and not just doing a complete tear down and rebuild, although, we see that quite a bit around here too. The applicant has submitted a stack of letters of support. We have not heard any objections to the proposed project at this point. That's all.
Thank you. Questions for Mr. Keeley?
Madam Chair,
Mr. Owen?
what's the civic association here?
Aurora?
Yes, so they had reached out to the Civic Association. I don't remember the name of it. I live in another part of Arlington. I don't remember the name of it, but they reached out to them back in March, I believe, and haven't heard anything back from them.
I think it's Aurora. The line between Aurora and Arlington Ridge is unusual. Yes.
Yeah, I spoke with the applicant, and he said he confirmed that the civic association is Arlington Ridge.
Yes. Oh, they're usually more responsive.
Yeah, they're a pretty active civic association.
Lost in the mail. Okay, any other questions?
And we just for the record, I think we just received an email from the adjacent neighbor, 1035 19th Street, 1039 19th Street.
Madam Chair.
Ms. Vaughn?
In the course of the day, I get a lot of emails. I will note that I have been copied on emails from at least one representative from ARCA. I will say I have not had time to read them all, but I believe it was in reference to this. It was just today, this late morning, early afternoon. But the gist of it seemed to be that they were acknowledging that someone may have sent something to them, but they haven't had time. They're busy and they haven't had time to address this particular case. So that it would confirm that they did try. And I'm sorry I didn't bring a copy.
I have a couple printouts.
It's summertime.
Okay.
They don't usually meet in the summers
So you
either.
have a copy of the letter from the Civic Association?
Not from the Civic Association, from the next door neighbor.
No, we just got that one.
You have that? Okay. Okay.
Thank you. Thank you. Questions, comments?
Madam Chair,
Mr. Owen?
I think this is basically a roughly reasonable request. I'm a teeniest bit concerned. I mean, staff is recommending denial of the rear yard setback, and I'm just the teensiest bit uncomfortable that the Civic Association hasn't fully engaged, because it was really remarkable. Usually in a situation like this, you can find something comparable. And looking at the aerial map, I think you guys, the staff said that for several blocks, they couldn't find a single person who was encroaching with the main building that far back. There's some accessory buildings that are closer to the rear lot line. So, I mean, to some extent, there could be a long-term change in the character of the neighborhood if a lot of people started using this as a precedent. And so I would probably feel slightly more comfortable if the Civic Association were on board. But and without the adjacent most affected neighbor, I would have been deeply troubled. But I think on balance, I'm persuaded that this is a reasonable request.
Mr. Melnick?
Well, when I saw this initially, I too was struck by the, complete lack of any comparable structures on interior lots, and what Mr. Owen was mentioning is, the support of the neighbors, and that's one thing. I mean, that goes toward the condition of, or the question of, would the proposal be detrimental to the public welfare and injurious to property or improvements in the neighborhood? But a completely separate requirement is, would the proposal promote compatibility of development with the surrounding neighborhood? And so that, the consent of the neighbors, that's one thing, but it doesn't make it compatible with the development in the surrounding neighborhood. And what I'm wondering, it looks, it's just quite, at least from the drawings, it looks like quite a large addition, quite huge compared to the way it is now. And, the rooms, the addition rooms, they also look rather large, and I don't know what efforts were made to try to bring it within the limits, or at least close to the limits, instead of, 10.1 feet to the wall instead of 25. But just because of, I'm not seeing, really any compatibility here. It just doesn't meet the first requirement for me. So as it stands now, I can't support it.
I can clarify, if the board likes, why the structure is so long.
Go ahead.
If I could hear that. So the first floor plan, this goes back to the aging in place component. Basically, the intent was to have the living room, dining room, and kitchen area more or less as is, and then the family room behind that be sort of a place for the children to play in a buffer zone. The office/guest bedroom is the component here which really kind of dictates the floor plan in their minds. Basically, that would be a full-blown bedroom, living unit where the parents could basically age in place, and it's on the same street level, so they could basically just walk right into the house and have everything on the same floor. They don't have to climb stairs.
have a question for staff.
Mr. Owen?
Does this zoning category have a total side yard requirement minimum, or is it just 8 on each side?
It's 18. It needs a side yard requirement of 18 feet. That's a 30%
Yes.
rule, which if we do the calculation, we give an average of 18. That's
So they have to have a total of 18 feet left on the combination of both sides, and by the strict application of the zoning ordinance, at least 8 feet on each side.
at least
as well.
8 feet on one side.
How close are you proposing to the left side property line?
I believe there is an exhibit that talks about that. Let me check. The idea is that the new addition would basically be just a complete extrusion straight back from the structure. They don't want it to hang out on the side, which the concern is that might look sort of strange. If you look at the survey from Axis, it's approximately 15.1 to the building, 15.1. Well, that thing pokes out. It's like a patio area. It might be 20.1 to like the primary face of the main structure, kind of from the survey.
So there's about roughly 10 feet left that would be buildable by right if you didn't go back so far. Is that right?
Virtually, it's something like that. I don't know the exact math, but theoretically, the side yard could take some of that density, but it wouldn't be the same, like kind of central footprint with the family room and similar components.
And the case that you're making is twofold. One is that it's better for the applicant to have it in different configuration, which is sort of an argument, but perhaps idiosyncratic to the family needs of this particular family at this particular time.
Sure.
But the sort of longer term case that you're also making is that it would be less compatible with the neighborhood to build so close to the left side because there's another property that's right basically up against the property line there. That's an argument that I saw you make in the application.
Yeah, that is true, and it's also just like the simplicity of the building mass. These my friends really, they like the the clean footprint that the
So here on the Board of Zoning Appeals, we have to examine what everybody else would like when they walk by it, right? That's what our focus is. So, so I think part of the argument you're making is that it's more compatible with the left side neighbor's placement of their house. Mm-hmm. And another argument that you seem to be making is that it better preserves the frontage of the house,
right,
which is the original house that is already, setting the character of the neighborhood. So, I buy those arguments, right? I think in this particular case, I think that they make a plausible case that the reconfiguration to push deeper into the rear lot line is justified by the advantages of preserving extra space beyond what they're required to do on the left side property line. Also, one other observation I made when I walked around, you can actually sort of see it in this aerial photo. The neighborhood from the street, as you walk down the street, is more eclectic than usual for Arlington. House to house to house, it's not like you notice that this house is different than all the other ones in the neighborhood because the neighborhoods are very different from each other, house to house to house, in terms of size, in terms of placement, in terms of architectural style. So, so this would be a neighborhood where more flexibility in look from the front street maybe is more appropriate in my mind. But I appreciate what Mr. Melnick is saying, which is that, in fact, he didn't even read you the worst part, which is that term is defined to mean placement. So it's an uphill climb to make that argument.
I just make the comment that they are essentially doubling the size of the house, and by going with such a large addition, which in and of itself wouldn't necessarily bother me, but it is an eclectic neighborhood. There are all kinds of interesting additions and already, and it looks like the house behind it has a pretty minimal rear yard as well. So that means the structures are going to be close together in the rear as well as on the side. And that's kind of a lot of structure in a fairly small space to me.
I agree, it's a close call.
Other comments or questions? Thank you. What's your pleasure?
I'll make a motion.
Mr. Melnick.
Okay, so in case V 1128817 UP, I move that the Board of Zoning Appeals adopt the attached resolution effectively upholding the position of the county. So that would be the resolution approval of right side setback only.
Is there a second? I will second. Discussion?
I guess, Madam Chair, I think it is, I think that the depth, I'm not excited about it. I think it is, when I look at the design and how the space is broken up inside, I think they could have reduced it some. It doesn't have to be 33 feet deep. It's not a big house to start with, and doubling the size is, I can understand it, and I can understand the need for the space. It's a big space back there. I'm comfortable giving some rear yard relief. I just don't know if only leaving 10 feet is enough, though. But I'm not comfortable denying and just siding with the county. I guess I'm somewhere in between.
Madam Chair,
Mr. Owen.
I wonder how the applicant would feel about, rather than potentially facing a flat-out denial tonight on the rear yard setback, if they would prefer a deferral to be able to submit new designs that did not have quite a severe a setback to the rear.
And I know they've invested a lot in this, but when you see the blue house on the next street over, you're going to have what's normally 50 feet of rear yard between those. It looks like probably 20.
The
Maybe 25 or 30,
it's
because
at least
they
25.
don't have 25 on, that blue house doesn't have 25 either, I don't believe. I would suggest they're less than 25 feet on the rear yard, probably in the neighborhood of 18. So I guess that's kind of, you have a storage space kind of behind, and that's a large kind of a rec room, if you will. The bedroom size, that second bedroom / office, is not large. I grant you. The width of the house is not, it's dictated by the width of the house. It's 24 feet. But just that area in the middle looks to be 24 by about 16 or so. And I just think that there's some wiggle room in there to reduce the rear yard. If there were a motion probably to approve as requested, I probably would vote yes, but I'm not going to vote to deny, but I wouldn't make a motion to approve what you've asked for. Someone else made it, I might join them. That's kind of where I am.
It's okay. I do this for a living as an architect. But that, and I hear you. That's. In all seriousness, I get it. You have to sort of manage density, and if somebody said, well, he did it, why can't I do it? It's. You're going to have that conversation. I think this house, this proposal in particular, it's kind of maintaining some of that narrow dimension in terms of the aspect ratio and kind of bringing that mass back. I think if the building, went out towards the house on the left of this image, you would see the rear yard all of a sudden snap right back. So. It's still, again, granted it is virtually doubling the space, but it's still, I think, 2% under the maximum lot coverage by right.
But it matters where it is. Mr. Owen asked you specifically if you thought that the applicants would prefer a deferral to consider a redesign as opposed to the motion on the floor, which is not to approve the rear, the relief for the rear yard.
They'd be fine with that. Yeah.
With a deferral.
I mentioned the deferral possibility to them, and they were fine with that. Yes.
Okay.
How much time would you need?
2 months, I'd say.
It would take 2 months.
Almost 2, yeah.
Okay, to get back on the agenda, right? That's probably way more than enough. They could probably handle it in 1, but I think that's fine, certainly.
Madam Chair, I'd like to make a substitute motion.
Ms. Malice.
In case V-11288-17-UP-1, I move that the Board of Zoning Appeals defer this item to the October 2017 meeting.
Second.
Substitute motion for 2-month deferral to October from Ms. Malice, seconded by Mr. Owen. All those in favor?
Aye.
Becomes the main motion. All those in favor?
Aye.
Aye. Thank you.
Thank you.
Thank you. See you in 2 months. Next case, please.
Case number V-11289-17-APP-1. Appeal by Westover Market and Beer House and George H. Rocker Company, the owner and the landlord, of a violation notice issued for violating the conditions of special exception use permit number U-3297-11-1 in C1 zoning district on premises known as 5863 Washington Boulevard. Staff recommends that the board adopt the attached resolution deferring the subject appeal to the September 2017 hearing.
Madam Chair, did we have a speaker slip from the applicant?
No speaker.
Okay. Then
Do we have an applicant?
Then I have some questions for staff.
Go ahead.
So in the packet we got, the applicants indicate that they are also seeking relief from the county board to change the site plan conditions and/or provide other regulatory relief to the property owner. Do you guys know if the appellant has filed any of the formal applications to the county board for such relief?
So, number one, Barnes is out of the country, so that's who's handling the appeal, so he wasn't going to be here tonight. The appellants filed a use permit amendment request in May to ask that the county board expand the number of outdoor seats. Staff advised them that the county board did not have that authority under a use permit amendment. And at their May meeting, the county board directed the county manager to study a zoning ordinance text amendment regarding outdoor cafes. Since that time, staff have been working on this issue internally through their normal process for handling zoning ordinance text amendments. And it's anticipated at this point, at the earliest, that it would go to the zoning committee of the planning commission is September, with assuming that things happen smoothly, a fall, possibly as early as November adoption. But there have not been any subsequent applications since the one filed in May that kind of started that effort.
What is the status of the violation while an appeal is pending before the BZA? Does having an appeal pending allow the applicant to continue to engage in the complaint of conduct without possibility of further enforcement? Does having an appeal pending limit the scope of liability for the appellant for any ongoing, uncured, asserted violations? That was easier to understand in writing than verbally. But basically what I mean is, does having this in limbo before us, how does that affect what they've already been cited for? And how does that affect possibly being recited on an ongoing basis for these violations?
So there's the Code of Virginia at 15.2.2311B says that appeal stays all proceedings. So we halt our enforcement action. It's an interesting question about what happens in the interim. Technically, I believe we could go and observe behavior if the behavior that's not consistent with the condition is still happening, and then depending on the outcome of the appeal, after that's over, issue citations at that time. That's not typical practice, but per the county attorney, there's nothing that would prevent us from doing that. So yes, they should be stopping the behavior. We can't write tickets, but after the appeal occurs, we could say we visited the site 10 times on these dates and observed the behavior and issue them.
Citations?
Yeah.
Cite them for each one, because what is it, 10,000 per violation, theoretically?
I forget the escalation.
So if the county board did a text amendment, that would not necessarily free them of the fines they've already incurred, right?
Exactly. And they would have to either amend or apply under whatever new provisions are allowed.
Okay. And what about the alleged noise violation? So you found a noise violation, is that right? As a zoning?
I believe it was a referral from the police.
So is there a noise in their use permit? Is there a noise condition in their use permit that references the noise code?
I don't have that. I don't know off the top of my head.
I think they said after 11, there was an issue after 11.
Thank you. Yeah.
Either 8 or 11, either 2,000 or 2,200, they said.
So sometimes what the county board will do is, even though the noise code is on the books and applies to everyone, no matter who they are, a use permit or site plan will restate that the applicant agrees to follow the noise code. And that can transform a code enforcement action into a zoning enforcement action, because then it's also a zoning violation. And so what I'm wondering, and it sounds like we probably won't get the final answer tonight about this, but what I'm wondering is that why the noise violation is before us as a zoning matter?
No, it's as Mr. Smith stated. It's not. Let me clarify. When you say noise violation, what I hear is decibels and sound.
Yeah.
And the condition relates to the time that the space is allowed, activity is allowed to occur. Right.
I see. So it's not really a noise violation, it's a closing hours violation.
Right.
Got it.
Yeah. It's a condition requirement.
And is the county board considering revisiting the closing hours requirement? Is there an application before them or any other formal action suggesting that that's under consideration?
No, the application that we have so far is about this number of seats.
Okay.
I believe there was I apologize, this is confusing because there were a couple of actions. There was also a request about expanding where live entertainment might occur, but that's a separate use permit and not the one that's the subject of the appeal.
So what happens if tomorrow night, Thursday night, it's midnight, and the neighbors say, my goodness, they're still playing music out there at midnight, way past 11, and they call the county?
They call the police.
Police.
Well, I said the county.
Okay.
But yes, that would in practice be who they would call. Because there's another issue about police enforcement versus code enforcement versus zoning enforcement. So I wanted to just collect the whole county into one entity, and they call the county. Then are you saying that because this appeal is pending, that the county's hands are tied to take action in enforcing that zoning rule, the 11 o'clock closing?
We would not be able to issue tickets or notices of violation and that sort of thing. We could certainly receive the information, record it, and act on it at a later point.
Yeah. Okay. Thank you.
So can I follow up on that?
Mike,
those
please.
questions? Your mic. Am I not speaking into the mic? So, starting with the last one, the applicant is appealing the noise or closing hours to us. So why, is there any reason that we can't proceed on that?
You could.
I mean, there's no board action, so could we schedule that for next month?
Well, that's why we have not agreed to an indefinite deferral.
Okay.
As a matter of courtesy, if an appellant asks for a deferral, we usually agree to a month. And so we have no objection to September, but an open-ended, because the board may or may not authorize a text amendment that eventually would, there's so many unknowns, and the timeline of that is unclear. We would agree to 1 month, but we personally are prepared to pursue it.
Since, certainly in that case, since there's no obvious remedy being pursued, that there's no reason to delay that one.
It doesn't exist yet.
Right.
The board has directed staff to work on something that may address it.
Hours issue?
It could. I mean, they've asked staff to look at outdoor cafe regulations. So in the context of, I mean, frankly, this complaint. So the complaint is what drove the direction to assess the regulation. So it's likely that something will come out of it that allows them more flexibility. It's unclear what that will be and how, what action they're going to take.
Okay. So, well, but at least in the other case, there was a notion that a text amendment was being drafted to address seating.
Oh, I see what you're saying.
Yes.
Got it. Yes.
In this case, there's nothing that's going to ZOCO next month.
I would say the early drafts that I've seen address this entire section. So it addresses the entire section pertinent to outdoor cafes.
All right, let me ask another question. So on the issue of seating, there was a discussion of successive complaints, that you could go out and observe, and every observation. Is it your intention to go out and observe?
Or someone's intention.
Or alternatively, if there's a complaint made, are you required to go observe?
Yes.
So you have not decided whether you will proactively go out and observe, but you would be obligated if someone complained.
Yes.
Go out every time and observe. Okay. Madam Chair, it's my inclination to go ahead and schedule this for September so that we can understand what's happening here.
Please.
I move that the county, that the Board of Zoning Appeals adopt the attached resolution deferring the appeal to the September 2017 BZA hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to defer to September. All those in favor?
Aye.
Aye.
Thank you. Next case, please.
Case number V-11290-17-UP-1. Use permit request by Ryan Fubini, owner, to permit a setback of 5.5 feet to the wall instead of 10 feet as required, and 5 feet to the eave instead of 6 feet as required from right side property line, and an aggregate side yard of 13.6 feet instead of 24 feet as required for a 2.5-story single-family dwelling in R6 zoning district in premises known as 1936 North Edison Street. Staff recommends that the board adopt the attached resolution deferring the subject use permit to the September 2017 hearing.
Madam Chair,
Mr. Owen.
in matter V-11290-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution deferring the use permit to the September 2017 BZA hearing.
Second.
Moved by Mr. Owen, seconded by Mr. Smith for deferral to September. All those in favor? Aye. Thank you. Next case.
Case number V-11291-17-UP-1. Use permit request by Susan Ross and Peter Luongo, owners, to permit a setback of 19 feet to the front porch instead of 21 feet as required, and 18.5 feet to the eave instead of 19.5 feet as required from front property line, and a setback of 6.1 feet to the porch instead of 10 feet as required, and 5.6 feet to the eave instead of 6 feet as required from right side property line. For a wraparound porch in R6 zoning district on premises known as 5111 27 Road North. Staff recommends that the board adopts the attached resolution approving the subject use permit with conditions.
Questions for staff? Hear from the applicant, please.
Hi, I'm Regina Prince. I'm the architect and here representing Susan Ross and Peter Luongo, the owners who are out of town this week. We're requesting to encroach into the front and the right side property line for a new wrap porch. Currently, the porch that is there exists into the same distance into the side yard. We are going to rebuild that to make it cohesive with the front, and then we're requesting to approach into the front yard to 19 feet as opposed to the 21 that is allowed with the setbacks. So it does keep in conformity with the surrounding neighbors. There's actually several new houses across the street which are quite larger. They're stepped terraces going down to the street, come almost to the curb. So we feel we're keeping quite modest with just, asking for these 2 feet as opposed.
Questions for Ms. Prince? Mr. Melnick.
So I actually have a comment. I commend you on the design. I think it's a great improvement, and just everything about it looks good to me. So I'm in support of it.
Thank you.
Madam Chair,
Mr. Owen.
in case V-11291-17-UP1, I move the Board of Zoning Appeals adopt the attached resolution granting the use permit subject to the conditions listed in the resolution.
I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick for approval. All those in favor?
Aye.
Thank you.
Thank you very much.
Next case, please.
Case number V-11292-17-UP-1. Use permit request by David and Lisa Driscoll, owners, to permit a setback of 5.7 feet to the wall of the addition instead of 8 feet as required from right side property line for a one-story right side addition, second story addition, and new front porch to a single family dwelling in R6 zoning district premises known as 2504 North Jefferson Street. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Questions for staff? Hear from the applicant, please.
Madam Chair.
Mr. Owen.
Yes, in the photo here, and maybe the applicant will have information about this as well, but on the right front of the property, you can see a little glass sunroom, and that's I think the location where we're talking about. Is that original to the house, or is that an addition that was built subsequently to 1949?
We purchased the house 10 years ago, and I believe that was an addition prior to the purchase of the home.
Okay, so my question is, did that addition require a permit? What's the legal status of that addition?
I'm sorry, I'm not sure. I really don't know.
That's
the
a question
answer.
for staff.
Yeah, I was asking them.
Oh, I'm sorry.
It's okay. So
Anticipated you would know.
sounded like I might be asking you soon, which I am. I might be.
Yeah, I received the question you sent, and I did have an answer. I did not find any plat for 19 or plans date back to 1949 that confirm if the sunroom existed then. But the plat for 1952, which I deducted from the 1952 plat book of Arlington County, shows that portion of the building, which unfortunately I do not have copies here, I have my own copy here, shows a feature that is similar to what is on that picture. But when I looked at the plat, the existing plat that is provided, and what is on the 1952 map, and with what is shown on that picture, which I did not look, it looks a little bit different. I concluded that sometime an alteration was made to that building, but I could not find in the system any permit or variance approval that was done. So I concluded that no variance, no building permit was identified in the record. So I just know that an alteration existed.
The building, you're saying that your view is that that's not existing non-conforming, that that's just unpermitted?
Yes, that's my conclusion, because I could not find that record.
And then another question I have for staff is that the lot here is, I think you said in the staff report, 55 feet wide, and the zoning requires 60 feet?
Yes.
So why is this not a variance? Why is this a use permit?
Staff did not consider this to be a variance because it looked at it as a buildable lot that existed before July 2015. And in this case, what she was asking was the lot coverage was okay, the height requirement was okay, the building footprint was okay, so we did not see the need to advertise. I did not see the need to advertise variance in this case.
What triggers a variance on a non-conforming sized lot, like like this on a 55 foot? What triggers a need for a variance as opposed to a use permit?
Depends on when the lot was created. So 1950 is generally if it was created before 1950.
Which this one was.
It's accepted as it is.
So it's buildable without a variance. So they could even do a tear down and rebuild.
Yes.
And it would be buildable. Okay.
In certain districts, I should say. The ordinance outlines specific, because we do sometimes get them, I think it may be R27 or
right.
Certainly RA districts.
Right.
It's generally the R districts if it was created before 1950.
So for this lot in this district, it's buildable, even if with a total tear down, it's still buildable at 55 feet because it has been built on already?
Yes.
Okay, thank you.
Now, applicant. Please.
We'd like to build a porch.
Would you identify yourself, please?
Oh, I'm sorry. I'm Lisa Driscoll, the applicant. And we are taking the structure that's there and pushing it back some and bringing it in slightly to build a butler's pantry, essentially, that would join our kitchen.
Questions for the applicant?
I'd like to make a motion.
Please.
Okay, so in case D 1129217 UP1, I'd like to move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions as stated therein.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith for approval. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11293-17-VA-2. Variance request by Army Navy Country Club, the owner to permit the installation of a protective net and poles with a height range not to exceed 55 feet instead of 35 feet as required for a new protective net and poles bordering 18th Street South on an existing driving range in R6 zoning district in S3A/R6 zoning district, premises known as 1700 Army Navy Drive. Staff recommends that the board adopt the attached resolution granting the variance with conditions. An alternative resolution has been provided should the board wish to deny the variance.
Questions for staff?
So I note that just this moment, we have all received the June 7th, 2010 County Board agenda item, and I'm wondering if staff could describe what this document is and its significance.
Yeah, staff brought this document in because in reviewing this application, I was trying to see if there was any condition prescribed in the county board report that gives guidelines as to how the golf course could be used in terms of the protection or safety. But I did not find any guidelines in these use permit conditions. So that was what guided my review for this application. So I just brought the approved staff report to show that. Also attached is the minutes for that hearing.
So is this an update of or replacement for the 1986 use permit, or is this a fresh use permit for the construction of the clubhouse?
This use permit, it was the demolition of existing structures that was there, and the rebuilding of a new structure, including tennis courts, while maintaining the existing golf courses.
So is the 1986 use permit still in force?
I believe it's still in force, yes.
Okay, and we don't have the text of the 1986 use permit before us, right?
The 1986 use permit?
It's mentioned in the applicant's, no, in the staff as well. I think in your staff report.
1985.
85.
I could not get the original copy for 1985 in the record. This one was the amendment for the 2010 approval.
Okay, and just briefly flipping through this, it does appear that the 2010 use permit at least has plats showing the location of the driving range. So what I'm mostly interested in is, do any of the use permits applying to this property require the applicant to locate the driving range in this section of their property? Or would they be in, if they moved it, I mean, so sometimes use permits you file, and it says in accordance with the submitted plans, et cetera, and so my question is, does their submission or their approval prevent them from moving the driving range to some other portion of their property?
I haven't, not having reviewed either the 1985 or the 2010, it's difficult to comment. It sounds like the subject of the amendment was for a specific component that didn't address the driving range. We'd have to probably try to look back at what the 1985 and if there were drawings associated with it. Sometimes for use permits, especially the older ones, they're not quite as narrowly defined as we do things now. And it might have just been the use itself is what was, especially since the use was established before we even required use permits. Sometimes in those cases, they don't even submit drawings.
Right.
It's just we're formally getting a use permit on the books for something that's been in existence.
Right. So I note that in 2015, there was a similar variance request to tonight's request for screening at 55 feet. I listened to the tape for that one. For that one, the staff recommendation, the zoning administrator's recommendation was denial of the variance, and now the zoning office's recommendation is for approval. And I'm wondering what's the rationale for the change in posture between then and now?
I listened to the tape, and I made the conclusion that since the driving range is existing and no change is not a new proposal, and the protective net that is there is existing, I came to the conclusion that there's no reason for me to recommend denial because the golf course is already in use, and I took into consideration safety reasons and the use. Is it a new use or an existing or proposed use? So I came to the conclusion that I should recommend approval because it's an existing golf course which is approved by the county board, and for the use to for them to use the golf course properly, I conclude that this protective net will be good. It's a good. I recommended it for approval.
Thank you.
Applicant, hello.
Good evening. Nicholas Cummings here from the law firm of Walsh, Colucci, Lubois, and Walsh, obviously on behalf of Army-Navy Country Club. I appreciate all the comments from staff, and I think that kind of captures what we're trying to do here, that this is really about being good neighbors to the folks on 18th Street. The club is doing this of its own volition, obviously funded with its own money, which is a relatively substantial project to go in and erect a higher net, but it's necessary because I appreciate that, the existing height of the net simply isn't sufficient to stop golf balls from traversing the nets and landing on the residential property. And I don't want to give the impression that this is something that's happening a lot. It's not. It's an inconvenience to the residents nearby, but it's one that the club has been happy to deal with by paying for broken windshields and things like that as it comes up. Not an issue that is certainly coming up frequently. The club has been around for many, many years. Obviously, the use permit was obtained in '85. In 2010, we did a full renovation of the club. The clubhouse was rebuilt. The clubhouse is the only structure on the property that is the 55-foot height, which you can get with the exception from the county board. The other structures, here the netting, are only allowed to be 35 feet in height, hence the request for the variance to raise the height. We feel strongly that we meet the technical requirements for variance under the Virginia Code, especially the opening two. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property. We feel strongly here that the strict application of the ordinance simply wouldn't allow the net to be high enough to prevent all golf balls from traversing over the net into the residential property. There were some different issues last time with the 16th Street side, just because the whole site is just very different. There's topographical issues everywhere. But that section of netting has been very effective. And so the intent here is to come before you all, and certainly this is the only way to get the net to the appropriate height that would prevent the balls from traveling over it. So the intent is to come here to you all and get permission to raise the net and give that same sort of protection to the single-family homes on 18th Street. And with that, I'm happy to answer any questions or address any further concerns that weren't addressed by staff.
Madam Chair?
Questions for Mr. Cumming?
Just one. So the impetus for the fence was complaints from the neighbors?
I'd like to just answer that by saying that the club sort of works closely with the neighbors and speaks to them frequently, and there's not so many over there that it's not hard to have a close relationship with them. And so when issues have come up, the club has obviously compensated neighbors for property damage, and knowing that we had previously addressed issues on the other side, the club wanted to go ahead and raise the net on this side if it was able to.
Okay. I have a question for staff.
Please.
So I'm just wrapping my head around the relationship between a site that has a use permit that governs it and then the underlining zoning ordinance to which a variance is being requested. Do you understand? So are we saying because the use permit is silent on fencing?
Just like any other use permit or site plan, well, I guess I won't get into site plans, but the general rule of thumb is unless there's a specific condition requirement that addresses it, you have to conduct yourself in accordance with the ordinance. And so, for example, if someone got a use permit and wanted to put up a fence, it would have to meet whatever the by right requirements were. If they want to exceed that, then you pursue whatever the appropriate action is. But it doesn't necessarily preclude anything from happening. Unless there's as Mr. Owen said, unless there's a specific reference to drawings or something specific in the conditions, then what the ordinance permits is what the guidelines we use for that property.
So if there had been on the drawings fencing that was shown to be a particular height, then the remedy would be a use permit amendment,
right,
as opposed to a variance amendment.
Right.
Okay.
Mr. Melnick.
So in the staff report, I noticed that it when it's talking about alleviating a hardship to the physical condition of the property, that they're noting that there is some variation in topography along the portion of the driving range, but they don't say what that is. And I'm just curious because it's hard to tell from the photos. I mean, I do see some hills. Has there been any measurements taken? For instance, on a 55-foot fence, what would be the dip? Offhand, what are the differences between the highs and lows on this particular topography?
I don't, and we did submit some drawings with the application, but I know that over there's not the same issue that there was on the 16th Street side, and that the real issue here is just that a 35-foot fence isn't stopping all the balls. Topographical issues are an issue throughout the site. I mean, there is some hilliness in the driving range area, and there's some of that's for drainage, some of that's for other reasons, but also it goes to the location of the driving range itself on the site. There are challenges with where originally that would have been put because of the topography as well. Just a little factoid, the driving range has been there at least for 40 years, potentially as much as 60. The golf pro, Mr. Walsh, who couldn't be here tonight because he had knee surgery, we're discussing this. Mr. Walsh, of course, grew up in Arlington, and the pro said that he remembered at least being 40 years old that the driving range had been in there. Art Walsh said that it was probably close to 50 or 50 plus. But so we're going way back. But in short, there's not the same issue on this side. But I especially believe under the very first prong that the strict reading of the ordinance would unreasonably restrict the utilization of the property as is permitted for the golf club. Simply because the golf balls are not being kept on the course. And again, and that's the intention here is just to do what we can to raise the fence for the neighbors on the 18th Street side and give them the same benefit as everyone else has gotten. And I just mean that in the sense of the other neighbors.
Right. Okay, thank you.
Thank you.
Madam Chair?
Ms. Malice.
So I appreciate your concern for the neighbors. I noticed that you have some neighborhood signatures here. Can you describe who you contacted, and was this all, or were there others, or kind of what that process was?
So the golf pro, Greg Scott at Army Navy Country Club, is the one who is the point of contact when incidences come up because he's kind of in charge of the driving range, and he reached out to the folks. He's close with at least a number of them, especially the ones who sent the letters, and I imagine those might have been some of the folks who've had property damage in the past, but I couldn't tell you that specifically. And so the outreach was kind of face-to-face with the people who live over there. There's not that many houses on that side. When I visited the site, I drove through that portion of the neighborhood, and I think you're talking about, you can see it on Google Maps. I mean, there's just a strip of homes along the fence, and then there's a few more, but the ones that are really in the vicinity, we're talking about, I think, 5, 6 single-family homes at most.
So you're not aware of anyone who opposed the fence?
No, sorry.
Sure.
Mr. Smith.
One quick question, Mr. Cummings. Do you anticipate lights or antenna or anything being placed on the top of the fence posts?
Nothing of that nature has been mentioned to me whatsoever.
Okay.
And just nothing has ever come up in any conversation I've had with the club about that.
Mr. Owen.
So, on the immediate previous item, we have a tiny restaurant that is trying to get a code text change to fulfill its business model, and not seeking a variance to put out extra chairs or to stay open past midnight. And, I guess it's unclear whether the applicant is legally required to put their practice tees in the one portion of their property that's surrounded on 3 sides by residential dwelling units. On the other side of the property where the board approved last year, the case made by the applicant during the hearing was that there was a steep ravine on that side, which there is. I'll note that the fence is not built in the ravine. It's built on the hilltop overlooking the ravine. But at least there you had the consent of neighbors who were the abutting property. Here the abutting property is a public street. And then there are neighbors on the other side of that street. So I think if I were the neighbors whose cars were being hit by golf balls, and someone said, hey, we can go get approval from the Board of Zoning Appeals in 2 months and build a taller fence, and you won't have to worry about that anymore, I'd be pretty gung-ho about it. But I'm not sure that state law contemplates that if you choose to build your batting cage or your lacrosse field or your golf tees or whatever sporting activity you're going to have, facing into your neighbors' houses so that the balls are directed towards your neighbors' houses, that the solution is to get a variance from the BZA for whatever height of netting will counteract that decision. I don't think that that's compliant with our legal requirements as I read them. I don't think that I'm highly skeptical that the steep ravine, which does exist on the other side, not on this side, but did exist on the other side, really was a factor there, but at least that was the allegation. There's no such, not even allegation of, when I visited the site this weekend, I observed that this location of this fence was somewhat slightly lower than where the tees were. Perhaps my guess would have been 6 or 8 feet lower maybe. But it's basically flat ground. And so I'm not sure that a variance is the right place to go to say, because our practice tees are too close to our neighbors, we should be able to build 55 feet. And this is a place where, I don't know if this is on your list of things to do, but if you get approval tonight, I think you have to apply with the FAA because of the proximity and the height and the hilltop and whatever at this location to the airport, because the poles will be so high off the ground near the airport. The county board, if it were to do a text change for sporting netting at the edge, could regulate things like the appearance of the poles, how far they are from the street, whether or not you have to have tree screening, all sorts of other things that people might be interested in. And the final consideration for me is that the Army-Navy Country Club is an amazing and historic institution, and golf clubs can last for centuries, far longer than the useful life of most variances that we grant, which might be the homeowner's life and maybe the life after that. But we might be granting a legal right here that has implications for centuries. And I think I would want a little bit more policy involvement from the democratic institutions rather than just signing off on this at the BZA. So I'm not inclined to support this.
Madam Chair.
Mr. Smith.
I think Ms. Malice was talking about site plan going through the county board versus BZA approval of a variance. Those kind of pop up, and it's a either or. Which is the easiest? I think the applicant said, or maybe it was Mr. Owen who just said 2 months is the quickest way. File for a variance, you get it done quicker. It's a longer process going for a site plan amendment to a site plan that's been granted and has been amended. I look at the list multiple times for a variety of things. And I guess, I know there was it was a fractious discussion that we had last year. It took a considerable amount of time. It wasn't just a slam dunk. And often, we had a long discussion about the backyard, this netting around a backyard athletic facility, if you will, in a neighborhood. Yeah. And the neighbors weighed in, and we conditioned the construction of it with a lot of colored netting, specific lighting, times of the lighting, etc. And I was hoping not to see another, safety net issue with the golf club come up because of how difficult it was before. And we did, I think, used the topography. And it wasn't. I think I didn't listen to the tape again, but I do recall it being tangential relationship to the application as opposed to being fundamental or central to the need. But I guess and I want to hear from staff. 55 feet is what they're asking for. If they wanted to ask for, I'm trying to reconcile. I know there's something in the ordinance about 35 as R6, but commercial, is is it 55 feet for commercial? Is there, that's a number that rings in my head in the ordinance somewhere. I remember we were talking about antennas too, cell phone antennas several months ago.
Oh, the additional 23. So for those structures, the interpretation has been whatever the maximum building height is, plus the allowance for, yeah.
The penthouse for.
Right.
Okay. All right. I knew there were some other numbers that were.
So that would be 58.
Okay.
Practically.
But that's separate, different from this. I am not. I mean, I'm generally. I can understand the concerns of the neighbors, and obviously the country club addressing those concerns by putting up, acting proactively, I think is really kind of the way you described it. But I guess I'd like to see a little bit more of a rationale for it in light of the other avenue that they have, which is a site plan amendment.
Other comments, questions? Would you like to address the issue that's been raised about site plan amendment alternative?
Sure. Certainly, if staff thinks that that's a viable way to look at this, I'd be happy to explore it. On the topic of moving the driving range, I don't think that's feasible at all. It's just not feasible, so it's not likely to be moved. But if staff felt that, deferring this and then taking a look at whether or not it might be more appropriate to look at this through something like amending the use permit, again, I think is what we would be doing. We certainly could examine that and then come back and discuss it more. I think there was a comment about the FAA. I don't think we had to do anything other than, there wasn't any issue really last time with the construction of the 55-foot net, other than obviously the discussion here, I'm not saying, but other than that, the actual erection of the net and everything was that was smooth. So happy to consider it. Happy to take you up on that offer if we think that that's best. But again, it's not going to be feasible to reconstruct the golf course because there's 27 holes there, and the way it would have to be rearranged, it's not going to happen.
Staff, what would the timing be for a use permit amendment vis-a-vis this proposed deferral?
I think the deadline for the October hearing is August 14th at this point. I'm trying to make sure, what part of this, is this in the R6 part or the S3A part?
R6.
Part of my concern also is that one of the required things that we must examine on the Board of Zoning Appeals for a variance is whether or not this is repeatable. And I think the staff report says, well, this is a gigantic site, and so it's unique because it's so big. I'm not sure how that relates to the uniqueness, though, of the issues that are presented, because, in fact, what's driving this problem is the tightness. That the applicant is asserting that there's no other viable place to put the driving range, and so that has to be up against the houses. And so these issues are actually at least as likely, if not more likely, to occur on smaller sites. So if you have a sports facility that has a batting cage or a, whatever other, soccer ball, soccer stadium or whatever, that soccer field, you're much more likely to eject sports equipment the smaller the site gets. I think Arlington characterizes itself as an urban community sometimes, and this is natural. If you're in Manhattan, has driving ranges, I think, and they have netting around them, and they're highly regulated by the Democratic authority. I don't think they get variances in New York City. Yeah, so this may be something the county board's inclined to do with the textual change, because the general question of regulating sports fencing is a question of general applicability throughout the county.
So just to move the matter along, are we proposing a deferral past, a date past when the applicant could reasonably
That was why,
expect a-
that was
a
my,
board hearing?
that was my question, was we need some sort of a time frame other than just the obvious 1 month, if that's,
So it was August for November or for October?
October,
So it'd be September for November?
yes. I'm just looking at the R6 regulations, and it appears as though, in terms of what's outlined here, that the board is empowered to increase height, I think it was already stated, of one main building to 55 feet. It's silent on other structures, but in terms of what's outlined, what's an available option through a use permit or a use permit amendment, it seems limited. And I'm assuming that's why a variance was requested the first time.
because they already have their 155-footer.
Which would obviously be the clubhouse.
Yes.
So are you saying that the board could not grant?
So there's some general language that says except as otherwise approved in other in other previous sections. You know,
Reading.
yeah, I'd have to look into it further. But if you look at strictly what the exceptions are, it very clearly says one building on a site that's at least 100 acres could be 55 feet.
Mr. Smith.
I'm just looking at page 31 of the county board's item from June of 2010, and they approved in September of 1997 a 60-foot pole for an antenna, and then I mean they've done that a couple different times. So they've approved structures on this site that are taller than 55 feet on a number of different occasions. So there are several other structures other than the building itself. I guess I'm wondering why there couldn't be, for example, a notation in October of 2017 that renewed a use permit amendment for safety screening along the side of the. I'm just saying that 55 feet for that structure didn't seem to get in the way of other structures being erected for the purpose of antenna.
Yeah, we found that out in our research on antennas, that there were a lot of things that occurred.
No, I remember that. That's why I mentioned
That
it a
we
little
wouldn't-
earlier,
yeah.
because it dawned on me,
Yeah.
this antenna thing kind of weaves its way into the site plan amendments or variances. Because remember, we advised that gentleman from, MCI or one of the telecommunications company to go the site plan route
Right.
versus the
Right.
variance route.
Right.
And now the county, staff seems to be saying variance route versus site plan route. I'm not suggesting you're saying that, but it seems to be that's what.
I would just say we don't always take past practice as,
Precedent setting.
as what we've now determined is the more appropriate course of action. So for antennas in particular, we're treating things differently now than we did.
So if we were to defer this to October, would that allow the powers that be from your office and the county attorney and the applicant and everybody to make a determination as to how they want to proceed?
Sure.
And I presume if they weren't coming back to us, then that would just be dropped.
Right.
Madam Chair.
Mr. Owen.
So in the previous item on the beer garden, we heard that the county board had issued guidance to study an issue, and so that seemed relevant to us. So is October going to be time for the county board to alert the public that it plans to study an issue?
My understanding is that we determine if it's an appropriate alternative for them to seek what they're asking for. I think it would be highly unlikely that by October there would be that type of decision about whether or not we should initiate an amendment to look at heights of sports structures.
Yeah, see, and in my view, I may be in the minority here, but in my view, that's probably the correct, by state law, that's probably the correct policymaking tool as a textual change. And so I would be more interested in a deferral that was long enough for us to hear whether the county board was interested in that.
So, okay.
We take it one step at a time.
Sure.
In other words, find out what the appropriate mechanism is, and then if we find that a text amendment is the only appropriate amendment remedy, then defer the matter further out.
Yep. That's fine. I'm happy to go along with that. And I would just say that it would probably be helpful if staff would alert the manager to see if he wants to talk to the county board about this and see if, what the level of interest is in addressing the general question of netting for sports facilities that are pointed at neighborhoods.
Because, Madam Chair, for staff, I'm just wondering if, the question I have is, can any sports use come to BZA and ask for a 55-foot, schools or, the rec department or anybody? Or are there differences among different classes of applicants here too?
No.
They're all the same. So I think what we're talking about is kind of important in terms of what might be the pathway to getting a 55-foot fence, because I know in some neighborhoods, this neighborhood is clearly interested in some relief. Other neighborhoods might be very concerned about a 55-foot fence in their neighborhood. So establishing sort of a precedent pathway is a little concerning.
Okay, can we have a motion?
Madam Chair, I'm in the matter V-11293-17-VA-2. I move that the BZA defer this matter to the October 2017 hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to defer to the October meeting. All those in favor?
Aye.
Thank you. Thank you.
Time this evening.
Next case, please.
Case number V-11295-17-UP-1. Use permit request by Ken and Rebecca Dudlin. Owners to permit a setback of 8.5 feet to the wall instead of 10 feet as required, and 5.7 feet to the eave instead of 6 feet as required from left side property line, and an aggregate side yard of 17.4 feet instead of 18 feet as required for a two-story addition in the R6 zoning district on premises known as 56407 Street North. Staff recommends that the board adopts the attached resolution granting the subject use permit with conditions.
Questions for staff? Applicants?
Hi, I'm Rebecca Dodal, and this is my husband, Ken. I'm not sure if you guys need it. We did have one neighbor that was out of the country when we submitted our paperwork, but we have their,
Sure.
bring it up to you.
Bring it right over. Thank you.
Okay, anything you want to add? Thank you.
Nope.
No. I think you guys have all that information. We've been on the street for 10 years, and we moved to this house 2 doors down, so we're pretty committed to loving this neighborhood. So.
Okay. Mr. Smith?
I'd move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-11295-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Please note, Mr. Melnick was out of the room. 4-0. Thank you very much. Next case, please.
Case number V-11296-17-UP-1. Use permit request by Henry and Yulia Lehman, owners to permit a 6 feet high fence instead of 3 feet within the 25-feet triangle required for visual clearance on the left side, and 6-feet high fence instead of 4 feet as required within 25 feet from South Monroe Street right of way for a fence with associated columns in R5 zoning districts on premises known as 1117 South Monroe Street. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions. An alternative resolution has been provided. An alternative resolution is provided should the board wishes to deny the subject use permit request.
Madam Chair.
Mr. Owen.
I'm not clear on the nature of the advertised variance. The language in the application states that the variance sought is to maintain the 6-foot high fence on the side lot line on 11th Street, including 2 6-foot high fence posts on the front corners. But the advertised variance includes language for, quote, 6-foot high fence instead of 4 feet as required within 25 feet from the South Monroe right-of-way. So it's unclear to me if now, I believe that there is a 6-foot fence on the right side property line as well. So it's unclear to me if the advertised and requested variance includes that 6-foot portion, as well as the 4-foot portion on the front side of the property line that's within the 25-foot triangle where only 3 feet is allowed.
Yes, the 6 feet on the right side is within the 25 feet distance from South Monroe Street, so it's included in that in this request. And also the 4 feet is also part of it because staff showed them, if you would show the plat. The next slide, please. What staff tried to show on the plat that you see there is the 25-feet triangles which is required for visual clearance, and we show another distance of 25 feet from the front property line to where the fence is supposed to be, the maximum 6 height within that limit. So the 4 feet high fence and the 3 feet high fence within that triangle, and the 4 feet and the 6 feet are all part of this request.
So the street right of way and the curb line the same on these streets?
From South Monroe Street, 4 feet from South Monroe Street, a 4 feet portion of the lot is reserved for street and utility purposes. Then you have additional 6 feet which is used for sidewalk. So staff took the measurement from the edge of the street, as from the edge of the easement of the street which is reserved for edge of the easement which is reserved for public street purposes and utilities. We measure the 25 feet from there, then get a 25-feet triangle.
And how about on 11th Street? Is the curb and the street right-of-way in the same spot?
On 11th Street, the curb is out of the owner's property. Part of it is within is where you have the sidewalk. Part of it is inside the owner's property.
I don't think I understand the answer. So on Monroe Street, the curb is not the street right-of-way. The street right-of-way is closer to is not in the street. It's over the curb on Monroe Street. And so my question is the same thing true on 11th Street? Or is the street right-of-way on the curb, in the street, or above the curb, closer to the sidewalk?
The curb is in the street right-of-way.
The curb and the street right-of-way are in the same spot?
Yes.
Okay. Because...
Madam Chair, isn't this because there were that extension that's kind of bumped out into the street a little, that rounded area? And so it was actually, it looks like that was all redone. All those sidewalks were redone when this was built. But it looks like there is the property line and what do they call that? It's the easement for public sidewalk and utility purposes. That line and then the property line, it's kind of odd because they look like they're saying both are easements for utility purposes, and you can't really differentiate.
So from the text on the staff report, page 4, first full paragraph, it says that the 6-foot brick column is located approximately 11 feet from the curb on Monroe Street, but there's a 5-foot wide public street easement on Monroe Street. So that would say that the post is only 6 feet from the street right of way on Monroe Street. Do I have that right?
No.
11 feet minus 5 feet.
Right, so when to get the distance from, of the column from the edge of the street, staff used the distance where the property line of that lot is for the purpose of determining distance.
I see.
How far it is from the edge of the street.
Okay, thank you for explaining that. I'll just observe that seems to be at odds with the text of the ordinance, that measurement criteria. So, yeah. Mm-hmm.
I agree.
Yeah. Okay, I think that's.
Other questions?
I'll have more questions later. But that's
Applicants?
Good evening. My name is Julia Lehman, and this is my husband, Henry Lehman, and we are residing at 1117 South Monroe Street, and we are the actual applicants. So on June 2016, we applied for a permit to install the fence around our property, and we made multiple trips to the department discussing with them the project because we wanted to make sure that there would be no discrepancies involved, because we explained to them that it would be a steel fence and it's a see-through fence, plus there would be brick columns, brick tiers involved in it, so we wanted to make sure that we followed all the directions. So the permit was issued to us, and the permit stated that we had to install a 4-foot panels in front of the house and 6-foot panels on the sides of the house and in the rear of the house. So we followed the permit and we installed the fence exactly like the permit, like it was explained to us by the department. So, and like I said, it's a see-through fence, it's a steel fence, and it was in fabrication shops for 6 months because we had to design 2 different sets of panels, 6-foot panels and 4-foot panels. Plus, we had to match the brick for the brick tiers to match the house. So it was a very time-consuming and very expensive project as well, even though it's not that important, but it's important to us. Anyway, a year later, we were contacted by the department stating that there were actually some discrepancies with our fence, and we were talking about this 25-foot setback on the right side that we were not aware of. And they were talking about the triangular area, about the 3-foot, but as you can see, there's the sidewalk over there, and there is no fence installed over there. Just a little part of the brick tier falls into it. But we were told before that, hey, since this is just a brick tier, don't worry about it. It was part of the retaining wall, so it's not the fence, so we don't care about the height. That's why we went ahead and we installed the brick column the way it was. So we were told a year ago that we had to modify our fence. But unfortunately, it's not just a wooden fence. It's not the solid fence that's so easy to cut back. As you can see, every panel, there are different panels, and every panel has a centerpiece. And it's not that easy to cut those panels down. Besides that, if I'm looking on the within that 25-foot setback, I have to cut down 2.5 panels. And I'm thinking about the aesthetical aspect of it, what it would look like. Plus, there are 4 columns within the right line, and they are equally distanced. So if I have to do it, I have to remove the columns, and it actually ruins the entire design, not only of our house, but the entire development as well. And we designed the fence where it matches not just only our house, but the entire development, because they have gates and they have columns which are 6 foot tall. So it doesn't look odd. It looks exactly like the rest of the subdivision. Then it doesn't pose any safety concerns, neither to pedestrians nor to the drivers, because it's a see-through fence. It does not block any view. So we are requesting to keep the fence as is, the way it was installed. That's why we applied for the use permit.
Thank you. Questions for the applicants?
Question for staff.
Okay, thank you. Question for staff, Ms. Malice.
So one more time, staff report says it was not built in accordance with the fence permit that was issued. Do you recognize that, or?
No, it was built according to the fence permit that was issued in 2016. The drawing that you just looked at, as you can see, it has the date July 2017. The red markings were added a year later. About that red triangle. It was, as you can see, it was in July 18th, 2017. Back in 2016, nothing was ever mentioned about a 25-foot setback. Because if it was, it didn't make any difference to me. I was designing the fence myself. I would have designed exactly the way they told me. I would just put right over there the column, the brick column, and then would just go down and put 4-foot panels. It didn't matter. Because to start with, to be honest with you, I wanted to have a 6-foot fence throughout, but it was explained to me that in Arlington County, the front fences have to be 4 feet. So I was, okay. So I had to design different panels to do that. But it didn't matter at that time, because when we received our permit in 2016, there was no fence installed. It was only kind of the project to have this fence.
So again, directing it to staff, do you have anything that demonstrates that they've built this incorrectly?
So we have a copy of the fence permit,
Are you looking?
which says it's in the packet. It's right before the pictures.
The additional submission.
No, it's in the
Ms. Malice?
it's in the meeting packet,
This little note.
right?
Oh, yeah.
Which indicates 6 foot high in the rear and side, 4 on the front from the edge of the easement, and 3 feet high in the triangle. Which
On the left side triangle.
clearly, if there's any part of the fence that's higher than 3 feet in the triangle, it's not consistent.
Well, this says 3 feet high on the left side triangle.
That's the visual clearance triangle.
Oh, why does it say left as opposed to?
Well, that's the issue for us to decide, because one natural interpretation, given the state of the law, is that there is a triangle described by the zoning ordinance only on the left side where the streets intersect. And there is no triangle on the right side because no streets intersect there.
It's visual. It's for a safety.
Yeah.
So,
Madam Chair, real quickly, but Yulia, you didn't construct the fence. You handed this off to a construction company and the plans, and they built it, correct?
Correct.
Yeah, she designed it.
I designed the panels, the design of the panels.
And the plans that you designed were submitted to, you designed the panels.
Yes. Yes.
Okay. And,
But the actual installation was performed by the contractor.
right. And they laid out where the posts would be and the construction of the posts and all of that. And they submitted overall construction plans to the county.
No, we submitted. We were doing it.
Okay. You submitted, did you draw up the plans yourself?
Yes. Yes, I was talking to the department.
Did you receive, Henry Lehman,
Yes, me.
you received this fence permit, this piece of paper?
Yes.
Okay. at the time when you received it, did you understand what 3 feet high on left side triangle meant?
Yes, we discussed it, but it was told to us that since there is no fence installed, as the matter of fact, if you look at the original plat, there is a little small triangle over there. I don't know if you have it over here. It's actually much closer than this red marking is showing. And it was told to us, since we were planning to install a brick tier and it wasn't the fence, it was okay. They didn't care about the height back then. They were mostly concerned about the triangle. It was discussed to us that it has to be 3 feet, but it was told to us, since you are not planning to put anything over there, so don't worry about it. Because the biggest issue...
Panel.
Yes, in terms of the panel, because they were so concerned that we would put our panels on the other side of the sidewalk and would block the public right-of-way. That was the biggest issue that we were discussing back in 2016. They made sure that we understand that because the public's right-of-way is right on our property, and they were so concerned that we would go ahead and block it, and we told them that no, we wouldn't do it. So those were the major discussions back then. Yes, we discussed this 3 feet triangle, but we did a lot of measurements all together with various representatives of the department, and it's impossible even to install anything because of the intersection of both sidewalks in there. So there is no fence installed within that triangle anyway. There is nothing there.
I think your triangle is different than the triangle we're looking at.
The second page here.
Well, no, they're saying, when you look at this, the triangles, the outside lines are on that outside line, and their fence is that inside yellow line.
Right.
So they're saying that they didn't really put any fence in that triangle, so they didn't have to worry about 3 feet.
Exactly.
I hear you.
Yeah.
I see. I understand exactly what how you perceived it.
Madam Chair?
Mr. Owen.
In the staff report on page 2 is an excerpt of the visual diagrams from the zoning ordinance showing the 25-foot markings, or the 25-foot triangle, which I note is drawn well inside where street is depicted, right? So 25 feet goes from the lot line in this drawing and not from what looks like a curb being depicted. Although it's just a line, so what does it really mean? But I'm more interested in the second drawing of a tree. And it says clear of obstructions, and then it says between 3 and 10 feet. And there's a tree trunk right there in the middle, seeming to imply perhaps that a tree trunk, I don't know, maybe...
It's not an obstruction.
Yes. Yeah, I guess you could draw from that an inference that a tree trunk is not an obstruction.
And only the flowering top part is where...
Yes.
That's how.
But there's no text to support such a drawing.
How it's been interpreted for as long as we've had this,
So
to
you've
my
interpreted
knowledge.
tree trunks are not an obstruction, but trees are. And
Yes.
perhaps that a tree trunk is similar to a column.
Yes.
And branches are similar to a fence.
And their ability to obstruct vision.
It's like a brick
Okay.
to me.
Can we go back to the photographs of the fence? I'm sorry, are we finished with the testimony of the applicant?
Well, they're answering your questions, but I think they are finished.
Well, okay. When we're ready for discussion, I have other questions.
Go ahead.
Okay. So can you flip through slowly the picture? Another one? There. Okay. So what I see here is a fence. It's actually please stay on this picture, but what I'm interested in is to imagine you're actually on 11th Street instead of Monroe, right? You can see how the fence that's next to us is not very transparent. Even though the fence that's far from us on 11th Street, you can clearly see the car. And so the fence is transparent when you're looking at it perpendicular, but when you're traveling along it, it does have a lot of blocking of the transparency. And I think that part of the safety concern here, also I'll note that the fence is beautiful, by the way. It is a beautiful looking fence. The craftsmanship and the design is really lovely. And it's really just a lovely looking object. However, it's not regular, right? It's got art on it. It's got a design on it. And so that also reduces the transparency as compared to the link fence that's described in this section of the zoning ordinance. That for playgrounds, the county board says you can have a chain link fence, but it specifies only a chain link fence. So I feel like if I were a bicyclist approaching this one-way, ordinarily we call it a two-way stop, but here it's a three-way intersection, so it's a one-way stop. If I might be concerned about cars just blowing through that intersection because they're traveling on 11th Street and they can't see me coming, either down the sidewalk or close to the fire hydrant on the street. So unfortunately, I do think that the policy rationale for this 25-foot triangle ordinance is in play here. My view is that it is a safety hazard for the exact reason that the ordinance is in there. I am sympathetic to not forcing the applicant to tear down the 6-foot section of fence on the right side property line. I don't see why that, given the configuration of the property next door, I don't see any reason to put people through that trouble. And I think there's more ambiguity about that. But I think there really is a safety concern. There was a complaint. It's not right. The fence permit text says 3-foot triangle. I think remains a dispute, or not a dispute, but there remains a lot of ambiguity in my mind as to exactly where the triangle goes. I don't know if you had to reduce the fence height, my guess is that you probably wouldn't, you can say whether you would or not. My guess is you probably wouldn't want to keep the column at its current height. But if you did, I don't think that's a big deal. I think that the column is like a tree trunk. So, I'm not going to say that seems like, I think that given the guidance that's in the ordinance, that the fencing is an obstruction. It's like the leaves on a tree. I think that the post is like a tree trunk and is tolerable given the circumstances of this variance.
But moving
Mr.
down.
Madam Chair,
Mr.
just kind of dealing with a little bit of that. One of my favorite restaurants is the Broiler. I go there about weekly for a tuna fish sub, which you can see there. I go down this street all the time, and I drove down the other day, and because I was looking for 1117, it's like and I noted, it's this corner, and that's just the fence, and that's phenomenal. But I wasn't really clear on the 3-foot triangle until looking at that earlier plat, number 23 up there, Blake, I think it is. Can you go up to that slide? Yeah. See that triangle, their lot line, their property line is not the yellow line. Their property line is that dark, bold line on the outside. Those are public easements that are taken from their property. That triangle is their lot line. That's outside of where the fence is. There isn't a 3-foot requirement inside of there, I don't think. And if there is, it might be 8 inches. It might be the very tip, just on the outside of that column. But I just, because that red triangle is, but it says 3 feet is what that, and that's not, so anyway, I don't, and then the other point is that if you're on the sidewalk, that acute angle is, Mr. Owen, when you look at the fence, it does look, going back to, I think that was number 26, Blake? Yeah, that was the one you were looking at. Well, cars don't travel on the sidewalk, really, and a bicyclist would be in violation of the law if they were riding on the sidewalk there, too. And you're not, and that's an acute angle. When you're at that wider angle, the more obtuse angle in the street, you can see clearly through that lower fence, and of course you can, that other one doesn't provide the obstruction. But if you're standing, 2 degrees off of a series of poles, those poles are going to look like a fence. Mm-hmm. But if you go to 60 degrees off of that pole, you can see through all of those poles. It's a visual effect. So I'm just like, it's 9:25. I'll give them what they want. That's my view.
Madam Chair.
I'll give them what they have.
Ms. Mouse.
We often, lately, it seems like we've had cases where something that was approved turns out to be not approved, and we have this dilemma of, we have someone complaining that they don't like what they see versus the homeowner who has, done the work and put in the money and stands to lose something if the decision goes against them. In this case, the complainant is not just a next door neighbor or someone that lives across the street. It's potentially many people who use this intersection, and that's what I'm concerned about.
But
I'm concerned about the sight lines as has been described here. I also travel this area. That's the bank that we go to, and so I know this area, and I know what kind of congestion it is. So I am not willing to just concede this at this point, but I would. What's confusing to me is that there's so much disagreement on the drawings and which line is which and which is depicting what. That what I'd like to be able to look at is what does the remedy look like? If we were to make this compliant, what do we expect the applicant to do? Do we expect him to take the pier off? Do we expect him to just remove certain panels? And, is assuming that the fence is actually built in the right place, we agree that the fence is in the right place?
It's just the height of certain portions of it.
So I am not willing to just, overlook the fact that there's a potential safety issue here. But I want to know what we expect the applicant to do in this case. And I don't know if that means, I don't know if what other people are interested, someone describing it to me tonight or coming back at a later time and saying what the options are. Or if there's a majority that feels differently, then it's moot.
So if I could just clarify one thing with regard to the triangle. When you have a situation where you have easements for public street purposes, it changes where we measure setback requirements from. So, yes, the property line extends further, but because that first, 4 feet are dedicated from street purposes, that's the point along South Monroe where the triangle starts. I think can be confusing is in most instances where the lot line is and where the street right-of-way is are next to each other and there's not an overlap. So that's part of the difference here. Part of their property actually goes into the street, which changes where that triangle is drawn from. So what we've tried to approximate here, granted it's not the clearest on the screen, I'm looking at the paper, which I think is a little easier to read, but it's the more orange, which kind of appears red on the screen, is what we are drawing as the vision clearance triangle.
And I guess that, to me, that conflicts slightly with the text, because the text says that the curb on 11th Street and the street right-of-way on 11th Street are not in the same place. The text of the staff report says that the sidewalk, basically, is the edge of the street right-of-way and not the curb.
Got it.
And if that's true, the triangle would push farther into the property.
So, again, I'm trying to understand if we brought this into compliance, what would it actually look like? And that's
Any part of the fence in the vision clearance triangle has to be 3 feet.
And
the portions that are on the side that are within 25 feet of South Monroe would have to be 4 feet.
And is that a 4-foot stretch or a 2-foot? Not up and down, but I'm trying to figure out.
If it's about 20, yeah.
You guys are better at reading this than I am because so a
25 plus a 5-foot sidewalk, yeah.
So 20.
Everything on 11th Street would have to come down.
Okay.
No. Up to 25 feet.
Up to okay. Would the pier be allowed to stay in its place, or does that have to move too?
Everything that's within that distance. has to come down.
Would we have flexibility to keep the pier there and just have the fence go down?
Sure.
Okay.
And I'll just say I'm amenable to letting them keep the pier at the height that they desire, because I think that that's not a safety impediment more serious than a tree trunk.
Mr. Melnick,
So I'm in
save
agreement
us,
with,
please.
I'm in agreement with Mr. Owen. You know, I think that the triangle that everyone's discussing is very valuable, and I'm persuaded by the photo, and even the photo in the staff report showing some impairment of being able to see through it. I was struck by that by the photos, but I'm also amenable to allowing the fencing outside of that triangle. That's just the triangle I'm concerned with.
And what are we saying, that the 25 is going and not back to where it's setting there, but back up into the property?
Is that what you're saying?
Is it,
well,
I mean, you're going from the property line, but now you're moving back to the other side of the sidewalk? Is that what we're talking about doing?
Well, the statute says triangle formed by the street right-of-way lines with the line connecting said street lines 25 feet from their intersection. So wherever, you know, and granted, it's not very clear here. I can see something called easement for public street and utilities purposes. There's also an easement for public sidewalk. But wherever the actual, you know, boundary is of the public street right-of-way, you know, that's the triangle, and that's what I'd say needs to be complied with.
But there is no fence there, and even if we comply, we're talking about inches. We're talking about inches, we're not even talking about feet.
That's why I think there's a disconnect, because I'm trying to figure out how much we're talking about, and we're saying
We're talking about inches, just 8 inches.
25 feet, and they're talking.
There's a difference between what's the triangle and then the 25 feet from the South Monroe right-of-way. So the 25 feet from the South Monroe right-of-way is roughly 20 feet into the property of fencing that's 6 feet tall, that should be 4 feet tall. In the triangle, which I don't know the dimensions, which is a much smaller area, is where it's supposed to be 3 feet,
Okay.
which could be a much shorter distance.
Because the point of the triangle doesn't start where the pillar is. The point of the triangle starts in the street and on the sidewalk.
I think it would be ill-advised for us to finalize this item if there's dispute of fact over where the triangle is. And I think there's manifestly a dispute of fact over where the triangle is. And it would be best if we received more evidence at a future hearing about where the triangle is, if this is the direction we're going to go.
Or approve what they have already up.
Well, let's see if the votes exist for that option.
I mean, A is, we don't know what the triangle looks like, and the staff have not provided a factual basis to establish what the triangle is.
You mean in that this is not sufficient?
For me, I would say it is.
Okay.
I would say it's sufficient for me, but there seems to be some dispute.
Okay.
A is, there's a dispute as to what the triangle looks like. B is, well, let's just approve what they've put up because it's there. And maybe there was an honest mistake in interpreting what the 4 feet, 25 feet from the front yard for the to begin 6 feet. That's along 11th Street, and then where the triangle actually is. Maybe they were just try their best. They submitted their plans. They built what they thought they had approved.
Mr. Smith, perhaps we could move this along if you made a motion to approve.
I move to, Madam Chair?
Please.
I move in the case of V-11296-17-UP1 that we grant the resolution approving the use permit, in this case, subject to the conditions that are listed in the resolution.
Second. Moved Mr. Smith, seconded Ms. Freshman to approve as recommended by the staff. All those in favor? Aye. Opposed?
No.
Fails. 2-3. Okay. Next.
So I'm personally willing to tonight approve the right side variance and all of the piers, and otherwise no further relief. But I don't think that my other colleagues are in the same place that I am. So in that case, I will move to defer this item to a time convenient to the applicant so that there can be further investigation of where the lines actually go and what it would look like. And I would say that I would want to explore at least knowing what happens if all the rules are complied with. That should be an option that's presented to us. And then we can sort of subtract which rules we do and don't think cause the safety issue or other issues.
I would support that because I'm having some difficulties making sure that everyone in the room is looking at it the same way.
I think it's clear we're not, and I also think that unless we have exhibits that are absolutely clear, or perhaps even a site visit,
and clear to
because I think to require cutting it down and leaving the 6-foot pier would be ridiculous.
Well, yes, okay.
Just ridiculous. And I think, I understand, but of course I would have supported it as is, so clearly. But I do think that if it's deferred, let's say for 2 months, and staff and the applicant and whoever decides all these things can give us much clearer demonstration of where all the lines are, I'd suggest at least blowing it up so that we're not looking at something that's the size of a matchbook. And I would also suggest that it be very clear of how you're going to change what is already there. We're not talking about a proposal to build something. We're talking about something that's there. So exactly where would you require a reduction and stepping and whatever, so that there would be no dispute that if that's what was required and they had to go to that enormous expense, if they chose to, that it would be clear, there would be no dispute about it, because I think it's very unclear.
Is that a motion?
I don't do motions.
I would ask staff, how long do you think it would take to be prepared for that?
2 months is fine.
All right. Do you happen to know the date of our October hearing?
No.
I think I have it. Oh, yeah. October 18th. Are you in town October 18th? Do you think that would be enough time for you to be prepared with answer the questions that we were asking tonight?
I'm already prepared. I don't need 2 months to be prepared. I have all the answers, sir.
For a redesign?
And no, I know exactly where the property line, I know exactly where the triangular area and everything.
Our questions for you. For you, it would be, what would a redesign look like?
Redesign, you mean if you told me to lower down the panels?
Right.
No, 2 months would not be enough.
How much time would be enough for you to be able to do that?
Reordering, remaking.
No, just a design.
Just the drawings.
Design of what?
Redesign that corner.
First of all, there has to be absolute clarity as to what height is required and where, down to the inch, before they can, if they're going to be required to do it, the redesign is not on their shoulders. They can't do anything until they have some sort of a decision from this government, after which they can take whatever we say and figure out how to comply.
May I add something, ma'am? We wouldn't even have to redesign the fence within this triangular area. there is no fence falls within that triangular area. It's just a small part of the column, and I don't see how I would reduce it to 3. I mean, it would be, this top would be 6, this top would be, the front of it would be 3. It's even impossible because there's no fence within that area.
Well, it's a matter of some dispute that has to be settled as to what's where and what height can be where. So I understand what you're saying, and I think we just need a whole lot of people to look at this and make a determination that if it can't stay as it is, the reasons why, and exactly on this plat, on an enlarged version of this plat, exactly how you have to go from what you have to what will be permitted.
Madam Chair, I would suggest that really is staff saying this is how it doesn't comply. So
yes,
this is
it's not you.
Picture. This shows how it would look, just in a crude way, and as is being described, a blow up of this plat to show where the triangle is, really clearly. That can even be done photographically.
It's really not on the applicant at this point. I mean, you have what you have.
Given that, then the applicant would be able to react. It seems like to me, Madam Chair.
Yes.
So I agree that would be really helpful so that everybody is understanding the potential, but also something that clarifies which line we're measuring from, where the property lines are, where the easements are. I think I'm personally confused as to
where to measure the 25 foot. Is that what we're talking about? No, we know where that is, right?
No, Madam Chair, if I might.
Please.
We're really talking to the staff.
Oh, okay.
Them to come back with this.
We apologize.
It's their job to
You've already built something.
Educate us.
to give us the information that's indisputable so that there is no debate. They need to come back to us with that in a way that's clear enough so that when it's on the screen or in a piece of paper, everybody can understand it. And then that would show you what the county is saying you have to do to become compliant.
Are we going to be involved within that process? Because it seems like they may have some questions pertaining to the property lines.
Well, they may, but in terms of what is permitted, what the statutes say, it has to be this distance and this height and this, where. That's a matter of interpreting what the code says. And so what's existing at this point isn't as much of an issue yet. First, we have to be clear as to how this fence permit should have been interpreted. You should have been told something properly so that you could have built it properly instead of having it be retroactive. But clearly, my opinion did not prevail the first time. So, do we have a motion? I'm confused.
I think that
we have a motion, please, and move on.
Madam Chair, I move to defer V-11297-17-UP1 to the October meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Malice.
9-6, I'm sorry, 9-6, not 9-7, 9-6.
Thank you. To defer to the October meeting, and I think we've made it abundantly clear what it is we need to see by then. All those in favor?
Aye.
Aye. Thank you. See you in October. Mr. Smith.
V-11297-17-UP1 to the September meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor? Aye. Aye. Thank you. Next case.
Case number V-11298-17-UP-1. Use permit request by William Stoppel and Shannon Cummins, owners, to permit a setback of 18.4 feet to the front porch instead of 21 feet as required from North Nicholas Street right of way, and a setback of 17.7 feet to the rear deck instead of 21 feet as required from Fourth Street North right of way for a new front porch and rear deck addition in R6 zoning district on premises known as 1401 North Nicholas Street. Staff recommends that the board adopts the attached resolution granting the subject use permit.
Thank you. It appears, unless I'm missing something, that there's no applicant. We just defer it?
Madam Chair, let me ask, did staff receive any word from the applicant as to whether they would attend or not, and whether they knew of the hearing? I mean,
No.
Madam,
Do we have to have the applicant?
Well, typically, we haven't heard a case without an applicant.
All right. I mean, I thought it was a pretty easy approval.
Well,
That's-
I guess that can set a dangerous precedent, but
All right. Madam Chair, I move that we defer V-11298-17-UP1 to the September BZA meeting.
Second.
moved by Mr. Owen, seconded by Ms. Malice to defer to September. All those in favor?
Aye.
Thank you. We have two sets. We have two sets of minutes. May minutes, as edited, I guess you would say.
Madam Chair, we're still on the May minutes. I think those are just FYI, right? Didn't we already approve them?
I don't know why we were given these.
I think it's FYI. Is that right? Sam, did you?
We already approve the May minutes?
I'm suspecting that we did.
For May? We got May minutes in our packet, and I'm
Given May and
saying, was
July.
that just for our information? Because we already approved.
because when you look at the back of the July minutes, it says that Ms. Malice made a motion to adopt the May minutes as amended. The motion was seconded by Mr. Owen and passed 5-0.
So I presume that's FYI.
Yeah.
Okay, so we've got July. Mr. Owen had already made the comment about Mr. Peter, so I assume you got that. I did have one question about, there were several places in here. There doesn't appear to be any page numbers, but I'm just looking at 11274-17, which probably is page 5, where in the text it says speaking in support of the appeal. And there were several places in here where it mentioned appeals on text of use permit. So I just note that because it confused me. Typically, it should say use permit on use permits and variance on variances, and it usually does. But there were several here where it said appeals, so if that could just be corrected, I assume it's just an error and we could correct that.
Which case is that, V-11274?
Well,
274
yeah,
is one.
274 is one of them. 273 also.
275.
Okay, 275, 275. What's this one? There are 275s.
Oh, variance and a use permit.
Oh, yeah, variance. Okay, so, yeah, both of them.
It might be the case in 7 and 81. You might have done that in all of them.
Yeah.
You might just block and you might edit that
Repeal and
that
replace.
macro that you're using.
Yeah, so it's just a case of referring to it as an appeal rather than a use pen or a variance. Other than that,
So, Madam Chair?
Mr. Owen.
The only other thing I noticed was on page 9 for 278. I noticed that 2531 Key Boulevard was said to be located in Lyon Park. And I think that may have been how it was advertised and or how it was in our staff report. But in fact, I do not believe that 2531 Key Boulevard is in Lyon Park. Yep. It's near to where I live, so I happen to know.
And I did make the point earlier, just in general conversation about returning to putting civic associations in the advertisements and agendas.
And Madam Chair, I noted in the minutes that the motion to appoint Mr. Imba secretary was described as acting secretary, and he had been acting, and we were appointing him secretary.
Right.
Which he noted, and he said he corrected.
Okay. Are we good? Do we need to wait for the corrections to approve these minutes?
I think all the corrections are clerical
Editorial.
in nature, yeah. So,
Okay.
Madam Chair, I move to approve the minutes as, with the changes noted.
Second.
Moved by Mr. Owen, seconded by Mr. Smith to approve the July minutes with the edits noted. All those in favor?
Aye.
Aye. Thank you. Move adjournment.
Second.
Madam Chair, I move to adjourn.
Second?
Mr. Smith, Mrs. Malice, we adjourn. Thank you.